Preparing for your workers' compensation deposition, presented by the Injury and Disability Law Center. We are a premier California law firm exclusively representing injured workers and their families in work comp matters. This information is intended only for general purposes. Depending on the parts of body and the issues presented in your case, your deposition will cover additional areas not discussed in this seminar. You will meet with your attorney prior to your deposition to address the particulars of your case and how to prepare specifically for your case. The deposition is generally held at an attorney's office or the court reporter's office. Those present at the deposition will be you, your attorney, the insurance company's attorney, the court reporter, and sometimes a representative from the employer. The defendant's goal in taking your deposition is to either deny your case or deny benefits, reduce their liability, or justify accepting your case and providing benefits. Our goal with the deposition is to allow you, the injured worker, to explain the facts of your case and your condition, and show the defendant that you're credible and legitimately injured, and that if your case were to go to trial, the judge would believe you. Being prepared for your deposition helps enhance your credibility. You don't always have to have exact answers or an exact memory, but prior to your deposition, you do need to spend time anticipating your answers. The questions that will be asked of you will include information about your current case. When your date of injury or dates of injury were, how the accident happened, whether it was specific or over time, were there any witnesses, what were your job duties at your employer, how long you worked there. You will also be asked about all the parts of body injured and what your current complaints are. Let them know all the parts of body or problems or conditions you have, even if some issues have resolved or gotten better. You'll be asked about treatment for your current injury, including the doctors you've seen, the type of tests you've had, what surgeries have you had and when, and what medications you've been on, and what medications you currently are on. You'll also be asked about your employment history. There are a lot of reasons why they ask these questions. Think about, at least in the last 10 years, where you have worked and what kind of work you did for those employers. You may also be asked why you left an employer, and there are lots of reasons why people change jobs. One way to not get pinned down is to say, the primary reason I left, and whatever the reason was. Write down a list of these prior employers prior to the date of your deposition. You'll be asked about your military history, and be precise about your answer. You will be asked about your personal history, including marriages and other names that you've used, as well as places that you've lived. The reason they're asking this is to determine whether you have any prior claims or cases, so they can see if you filed claims under other names. You'll also be asked about your medical history, both personal medical history and any industrial injury treatment that you've had in the past. This medical history will include questions about prior surgeries, prior fractures, prior hospitalizations. Write down a list of as much of your medical history that you can remember prior to the date of your deposition. Your memory doesn't have to be perfect. Talk to your attorney prior to the deposition if you think some personal medical treatment is so irrelevant that you don't think the defendant should have access to that information. You will also be asked about the history of any prior or subsequent injuries. Have you had prior work comp or auto accident injuries or slip and fall injuries? Have you had any new injuries, even to other parts of body? They will be entitled to that information. During the deposition, the testimony you give is given under oath and bears the same penalty of perjury as if the testimony were given in front of the judge in court. It's critical that you understand that you have to tell the truth, and that you can be convicted of a felony if you give false testimony. You should be aware that any person that makes a false statement for the purposes of obtaining or denying work comp benefits is guilty of a felony. During the deposition, the court reporter types everything that's being said and prepares a transcript. For that reason, there are particular rules that make the deposition go smoother and make you look more credible. Always answer verbally with a yes or a no, not a nod of the head or a shrug of the shoulders. Wait until the question is completed before you answer. This allows you to make sure you are answering the question that is being asked and not necessarily volunteering information. You're also allowing your attorney time to object if necessary. And you're allowing time for the court reporter to take down what you are saying because you are not talking over the other person, and that allows for a cleaner deposition transcript. Answer only the questions you hear and understand. It's okay for you to say, "I don't understand a word you're saying," or "I don't understand the question," and ask for clarification. But don't be defensive or argumentative. If you do not know the exact answer to a question, give your best estimate so long as you're not guessing. So if you've been in an auto accident in 1982, but you don't remember exactly when it was, it's okay to say 20, 30 years ago. Because if you give an incorrect exact answer, then the defendant and the court will assume you heard the question, understood the question, and gave your best answer to that question. Some questions, however, will require more precise answers, such as how many times you have been married, have you ever served in the military? Be very precise about those kinds of questions. It is okay to take breaks during the deposition. Should you need a break, tell your attorney. About 30 days after your deposition, you'll receive a copy of the transcript. You'll have the opportunity to review the transcript and make any changes. However, being prepared prior to the deposition will help you avoid needing to change your testimony. You want to make sure that you are prepared, because if you do make changes, and they are important changes, that could impact your credibility. As an example, if you've had a prior auto accident where you received a $50,000 settlement, and during the deposition you said you had no prior auto accidents and no prior settlements, and you eventually change your testimony when you review the transcript to disclose the $50,000 settlement, that would definitely impact your credibility. So the purpose of this seminar is to have you prepared for that deposition. You're going to make a good impression. You're going to come across credible and cooperative, and you're going to come across so the defendant sees you are a real person and not just a file. And the defendant will come away saying, this is a person the judge will believe and be sympathetic to. So you're going to do a better job by being better prepared.